So some good news on the Palworld Nintendo lawsuit front. Japan's patent office has denied one of the applications for a patent that Nintendo has put in that is related to the lawsuit. I'm also going to start by saying apologies if the quality of the video is low, apologies if the quality of the audio is low. I am currently in Pennsylvania visiting my father who's getting surgery, or who has just gotten surgery to have cancer removed, and I don't have my computer with me, so I'm using my girlfriend's laptop. The long story short of this, the bottom line up front of this is that one of the patents that Nintendo has applied for in Japan that is related to the patents that they are using against Palworld, against Pocket Pair Palworld, has just been denied with Nintendo saying, or not with Nintendo, with the Japanese patent office saying that there are essentially, it's not inventive enough. A lot of prior art was cited, including, what was it, Studio Wildcard's art, Capcom's Monster Hunter 4, Pocket Pair's Craftopia, and a Japanese browser game named Kantai Collection, and Pokemon Go. So all this prior art was cited. This prior art was all before December 2021 when they filed for the patent. And the Japanese patent office has essentially said, nothing in this patent is uniquely inventive enough compared to the prior art that was cited for this patent to be granted, which is, I think, everyone that has half a brain is in agreement with. Like, nothing that they're doing is nearly unique enough to merit a patent, and definitely not merit, one, don't patent video game mechanics, but two, it's definitely not unique enough to merit a patent and shouldn't be allowed to be used in this way, because Pocket Pair is ultimately not doing anything super unique compared to other games that have existed in the past. But what does this mean? What does this mean for the lawsuit? It's kind of up in the air. This is a good sign, because this is something that Pocket Pair, and particularly Pocket Pair's lawyers, can reach back to and tell the Japanese court, like, see, look, the patent office is denying one of these patents, saying it's not inventive enough, and if that one's not inventive enough and it's basically the same thing, then this one shouldn't be inventive enough. And two, one of the more direct kind of impacts it has is, I've gone over in the past of how, like, patents give priority to, like, there's a parent patent, and then there's, like, children patents that come from the patent that was given priority to. One of those patents that was given priority to was granted. That is the one that ended up being patent number. It was application number 2023-204842, and was granted as the patent JP7505852. That was the one that this one is giving priority to. This one that just got denied is giving priority to. It is the parent patent. This one that just got denied is the child patent. But this child patent application, the one that just got denied, that's application number 2024031879, gave birth to, or is acting as the parent to, a separate patent that was granted and is being used against Palworld. The patent was, their initial application was 2024123560, and it was granted as application number JP7545191. So that was a patent that they were granted based off of this application that wasn't granted. So that's one thing that Pocket Pair can point to and say, look, this patent definitely shouldn't be considered valid, because the patent that it is being derived from was denied, was not allowed. They denied it. One, I'd also like to point out, just as a little side note here, a lot of these patents take a while to grant. It takes like almost 18 months, 2 years, however long, to go from being applied for to being published, and then even longer to be granted. Yet 2024123560, the one that was granted as JP7545191, was applied for in 2024 and then granted in 2024. So there's definitely some expedited stuff happening here, and I think that's another thing that can be said. Like, listen, clearly some of these are being denied later, and this stuff is being too expedited, and you should look at that and consider that when you're considering whether or not they should be able to sue us over these patents, or they should get any recovery for that. Essentially, that's the effect that it can have on the lawsuit, from my understanding, is Pocket Pair can go back and go to the judge and say, hey, look at this. This got denied. This one's a child patent to it, so that one probably should have been denied too, and you should use your best judgment and, your keen mind as a lawyer or as a judge to not really go for that one either. So it gives them a little bit of ammo in that way, but the patent was denied on a non-final basis, which means that Nintendo has the opportunity to go back and change something. I've talked about this in the past in my video that came out in like June or July or whatever it was, where there's a process that you can do with patents, at least in Japan. I don't know if it exists in the United States. One, where you can just apply to change a patent after the fact anyways, for a few different reasons. If the language wasn't clear, if you're narrowing the scope and to fix typos effectively. Also, this is them saying like, listen, this is not inventive enough. You need to change this and amend it, and then we'll look at it again, kind of thing, or we might look at it again, kind of thing. So the patent isn't denied in finality in a way that's like, no, you just don't have this. Good luck next time, kind of thing. It's denied in a way it's like, fix this. So that does give them the ability to go back, fix the patent, and then unfortunately what they might do and what they have done in a previous case, I talked about it in that same video, I think, what they did in a previous case is have a judge tell them this patent is too narrow or this patent is too broad, and then they applied to alter the patent and update the patent and then narrowed it in a way that was more tailored to the lawsuit that they were going for, which is a super shady thing to do. But that might be something they try to do in this situation. Like, okay, they told us this is too broad. Now we're more aware of the defense that Pocket Pair is using and that their lawyers are using, so we can narrow it, but we're going to narrow it in a way that targets Palworld in a more direct way. That might be something they could do. They also have the ability to, once the official process at the Japanese Patent Office is over, they can go to the Intellectual Property High Court, IPHC, and basically appeal the denial of the patent. So they can drag it out even more and say, listen, we got denied this patent, we shouldn't have been denied this patent, I think they were wrong, and we want to file for appeal and get the patent approved anyways. It seems very much like I don't want to call it a self-licking ice cream cone, because I don't think that's the right analogy for this, but it seems very just like a process that is not overly complicated, but it gives these companies too many chances to be assholes. It gives these patent trolls and these companies that are manipulating the system and abusing the system, whether it's technically legal or not, it gives them too much of an opportunity to be dicks and drag this stuff out so it's damaging to other things. I think that's very, very wrong. The good thing though is the reason why this is good news though is that because of the fact that this one that's at the center of it, it's basically, okay, you got the original ones they applied for December 2021, and then that gave birth to the ones that they applied for in 2023, which gave birth to this one that they applied for in 2024, which gave birth to a separate one that they applied for and got granted in 2024. The fact that this one is invalid can lean to the other ones being invalid as well, potentially. So that's really good news in this, I think, to my mind. That is really good news, because that means that now they have a chance to fight back and go to the courts and say, listen, this one was denied. This one is very closely related to all the other ones. It was the child of one and the parent to another. Those shouldn't be valid either. We should not be getting sued over this, because even the Japanese Patent Office is saying this is an invalid patent. So that is good news. I wish I was able to take a little bit more time and to go into a lot deeper research on this and get a lot of the specific wording in the law right now. But again, I just got back from the hospital visiting my dad. So I haven't really had the time to. I saw this pop up on my phone and I was like, okay, I'm going to record something so at least I can talk about it. And I'll keep track on the future and see if there's any more updates on this. So with that, I'm going to end this video here. If you have gotten this far, please like, subscribe, comment, hype the video. All the different forms of engagement that will help the video do better. If you would like to support me in my fight against Nintendo and against patent trolling, please consider donating to the GoFundMe link in the description and in the pinned comment. That is to help me build a database of prior art, which will be very helpful for situations like this, because then it'll give both the law firms and the indie devs access to all the prior art that might be related to a game mechanic that they can use to defend the case, but it'll also give the patent office access to the prior art so that they can look it up when they're doing their research to confirm whether or not they should grant a patent anyways, and then be able to say, hey, no, this already exists. Also, if you would like to help me out in a more personal way, click on the playlist over there. That's my storytelling, or over there. That's my storytelling channel. It's a very cathartic process for me, telling these stories, editing the stories, getting the feedback on them. A lot of the videos used to be on my main channel, but because YouTube analytics, I took them down. I'm moving over to the other channel. And if there's a story about me getting pepper spray over there, so you might like that one. And if you want to help the channel in a more direct way, please consider signing up for memberships. The details are down below. Every dollar from the memberships goes straight to my editor until it reaches such a point that I can afford to hire him on full time, which will just allow me to put out more videos more consistently and yeah. But with that, goodbye. Fuck Nintendo.